firm's Food for Thought. We're so excited to have you here with us today. My name is Afton Strong. I'm the managing attorney at the family law firm. Joining me is our attorney, Jonathan Collins, who specializes in divorce law. When speaking with clients and prospective clients, we often hear some of the same questions over and over. So what this tells me is that there's not enough information online regarding these topics. So Jonathan and I spend time weekly answering some of these questions. As an added bonus, I provide a discussion on a family law issue that's in the media and discuss how these stories may relate to you or your friend. So let's get right into the issue for this week. In case you haven't heard, it has been reported that KimYe's is over. Numerous outlets have reported that Kim Kardashian intends to file for divorce from Kanye West after 6 years of marriage, and that they are actually in settlement talks. Kanye is currently living in his ranch in Wyoming as he has grown uncomfortable by the Kardashians' lifestyle, and Kim has become tired of Kanye's bizarre behavior, solidified by his recent presidential run. While they likely have a prenuptial agreement, the couple's situation has vastly changed since they first married. According to Forbes, Kanye's net worth has reportedly shot up from $100 million to $1.3 billion. And Kim's net worth has gone from $40 million to $780 million. A major point of contention between the two is their Calabasas family home. After purchasing their home for $40 million, Kim and Kanye reportedly spent $20 million on renovations. Kim is trying to get Kanye to concede that she should keep the house. She owns the land the house sits on and adjoining lots around the house, but Kanye actually owns the house. Kim believes that she should have the house because it is where she and the 4 children live. So this brings us to today's legal lesson: how separate property can become marital property. Now, obviously, Kim and Kanye are in California, so I'm just describing how a case with similar facts might play out in Tennessee. One of the necessary and sometimes complicated steps in a divorce is property division. As a part of property division, there must be a determination of whether each piece is considered separate or marital, as only marital property is subject to division. Generally, separate property is property that a spouse has before the marriage or gets through inheritance, gift, or certain types of legal proceedings. Any property which is determined to be separate property is not subject to division during a divorce. However, under Tennessee common law, there are 2 ways that separate property can become marital property: commingling and transmutation. Commingling is when separate property is mixed with marital property or with the separate property of the other spouse. Transmutation is simply when separate property is treated as marital property. So in KimYe's situation, we can see an argument to be made for the Calabasas home being treated as marital property, even though it's Kanye's home, since it was placed on Kim's land. The couple spent marital funds to renovate the home, consequently increasing the value of the home, and they treat it as their marital property by living in the home with their family and substantially contributing to its upkeep. So what did we learn today? Even if property was yours before the marriage, how you treat the property during the marriage can definitely affect how a court divides the property in a divorce. So now let's get to some of your questions. Jonathan, you can take it.
Thanks, Afton. The first question that I selected for today definitely piggybacks off of the legal lesson for today, and that is my spouse and I required to sell our home during the divorce? Now, whether the home is in both names or it's become marital property, homes often become big points of contention when spouses are going through a divorce. Now, does the home have to be sold? No, absolutely not. The home does not have to be sold. Now, many times it may make the most sense for the home to be sold, but certainly the home can be left to one of the spouses. Now, this may require some refinancing and some one spouse paying the equity to another spouse, but certainly the home can be kept. The next question that we chose for today is, do my kids get to pick where they live? And that's a tough question, and it's one that we see a lot. It's always a hard decision and a hard situation when you're talking about kids going in front of a judge and picking one parent or the other. The reality is that in Tennessee, kids that are 12 and older are able to give their preference to the judge to determine where they live, but that is by no means a binding preference, and there are a lot of other factors that the judge is going to look into when it comes to a custody situation. So again, yes, kids, if old enough, do get to express a preference, but no, that is not a binding preference by any means. The final question we have today is, am I responsible for my spouse's debts? Now, the short answer is yes and no. The reason I say that is because let's say that you and your spouse are jointly liable on a debt. Well, the reality is you are liable for that debt. The judge in a divorce cannot take your name off that debt. Now, it's possible that the judge may require one party to pay that debt over the other, but your name is still going to be on that debt unless that debt is refinanced. The other way that you may become responsible for a spouse's debt is if the judge orders you to pay that debt, even if your spouse's name is on it. Potentially, when the judge is dividing up property, assets, and debts, they could award, one party to pay a bigger portion of debt, which could result in one party paying debt that's in the other spouse's names. That's all the questions we had time for today. Tune in next week for a few more of your questions.
So if you have any questions about how separate property becomes marital property, or just about anything in today's episode, feel free to give us a call. Our office number is 901-308-8578. Again, that's 901-308-8578. Or you can email us at info@familylaw10tenn.com. And as always, we'll be back next week to answer some more of your questions. In the meantime, remember to keep your family close and your family law attorney even closer.